So, just as an overview, the Office of the Children's Lawyer is an independent law office within the Ministry of the Attorney General. So, we provide legal and clinical services to children right across the province. We have about 20,000 children who receive services from our office, and our head office is located in Toronto. However, we have clinicians that work for us, clinicians and lawyers that work for us all across the province. So from Cornwall to Thunder Bay, Sarnia, here in the GTA, and the in-house staff, so in-house clinicians and lawyers, they provide supervision to those clinicians and lawyers that are out in the various regions. Um, and so in terms of who the children's lawyer for Ontario is. Marian Jacko is the children's lawyer herself. She's been our children's lawyer for 4 years now, so it'll be 4 years this month. She has a degree in social work, a master's in social work, as well as a law degree. She used to be a lawyer in the office as well for a good 17 years. She then went on to the Indigenous Justice Division, the Mother Risk Commission, and then she came back to the office as our children's lawyer. So within our office, we have property rights department, which takes care of children's civil rights and property rights. We have the legal personal rights department, so that's where we have custody access child protection cases. And then we have the clinical personal rights department, where we focus on custody access cases. So custody and access disputes, the court basically makes a request to our office. So say, for example, we have two parties coming in complaining about, one person is doing something that they shouldn't be doing, the other person is doing something else. The court can't make sense of it in terms of who's saying what, and the court may decide, you know what, I think that the services of the OCL would be needed here. So they would make a request to our office. We would decide whether we would accept the file or not. And if we do accept it, we'll decide whether it'll go to a clinician, who is usually a social worker, a lawyer, or sometimes even a team of both. And we do get referred some of the more difficult custody and access cases. So I'll be giving you a couple of examples in terms of when custody access disputes, high conflict custody access disputes go awry. So in terms of the clinical investigations that we provide, once we decide that we're going to accept the case for an investigation, we review all of the documents that come in, so a lot of the legal documents. We interview the parties, so we meet with the parties, we meet with the children, we conduct observation visits with each party and the child. We speak to collateral sources, so we can speak to schools, CAS, police, if indicated, other therapists, social workers that might be working with the family, medical professionals. We also speak to personal collateral. So if there's a grandma or auntie, uncle that is really part of the child's life and really part of the parenting plan and the family core for that child, then we're definitely going to speak to that person as well. And so once we gather all that information, then we're going to provide some recommendations, and our recommendations are best on the best interest of the child. So it's not what the child says, it's not what one party says versus another party says. It's going to be all of the information that we've gathered throughout the investigation in terms of making a recommendation to the court on what we are seeing in terms of what is best for the child in this custody access dispute. And so our investigations typically last for about 90 days, but sometimes it could go a little bit longer, especially if we're waiting for some of those collateral reports to come in. So clinical considerations. So what are some of the things that our clinicians, when they're doing these investigations, are looking for? And one of the first things that we want clinicians to look at are, what are the strengths? What are the good things? What is happening in the parent-child relationship that's really a positive? Um, and then we start to look at some of the history, so the relationship history, the post-separation history, what are some of the family and community supports that the family has, what kind of therapeutic interventions, if any, exist. We also want to look at the cultural considerations. So, and sometimes what we see in our disputes is that culture can be repressed and oppressed in some of these disputes. We look at what is the current custody access arrangement. So how are exchanges happening? How are decisions made in terms of healthcare, education, extracurricular activities? How is that happening? Is it one party that's doing that? Is it both of them together? Those are the things that we're going to look at historically and presently in terms of the dispute. And we're also going to look at whether there is a presence of intimate partner violence, so domestic violence, alienation, is there substance use and abuse, mental health issues, instability, inconsistency. We heard a little bit about that earlier this evening. Recurring police and child welfare involvement. So are we getting a lot of those calls back and forth between the parties? We're looking at the child's development and if there's any developmental delays. So these are some of all of the things that we are assessing for in a custody and access dispute. And so once we gather all of that information, we then ask the parties to join us in what we call a disclosure meeting, whereby all of the information that we gathered over the course of the investigation is revealed to the parties. And you would think, well, the parties will know all of the information about the other party, they were in a relationship with them, et cetera, but sometimes parties don't necessarily know everything that is going on in the other person's home, which is probably one of the reasons why we're involved. And so this disclosure meeting, it also gives the parties an opportunity to not only hear the recommendations, but potentially settle the custody access dispute right there in that meeting, or walk away from the meeting and will eventually be filing a report, and then they can settle off of the basis of that report. And so once we file that report, then basically our involvement in that custody access dispute is closed. So even though the custody dispute may still go through the courts, our piece is done. We're in, it's a punctual service, we do the assessment, and then we leave. So I wanted to give you an example of an intimate partner violence case that we recently closed. It was a very serious case. We got the referral after the pandemic had started. And so this was a case whereby there was historic and severe intimate partner violence. So father was alleging that mother was mentally ill, that she was making unfounded claims about abuse. Mom, of course, was alleging the abuse. And what the clinician basically uncovered was that there was major features of cultural oppression. So denial of one race over the other race. And that basically, for example, mom in this case was seeking services that were very culturally appropriate and culturally based, and father would not agree to those services proceeding because he didn't feel that that was important. This father was also quite wealthy, is quite wealthy. And so there was a lot of financial oppression going on. And also extreme physical and psychological abuse, stalking, and I would even say that there was torture going on in the house with the children present. So in this particular case, what had happened was the onset of the pandemic was announced. The parents were still living together. However, things were not going well. The abuse was continuing. And so the children who were 9 and 5 at the time were basically put in a separate part of the home. And the father would carry mom into another area of the home and systematically torture her for weeks. Eventually, on one occasion, she was able to escape the home. And this is where he had threatened to kill her, kill the children if she didn't come back into the home. However, she left, she called the police, and multiple charges were filed. Um, so because of father's finances and resources, he was able to arrange a really liberal access arrangement. And so access continued with the 9 and 5-year-old, despite these very serious criminal charges and CAS involvement. And, and so as a result, the access with the children, that time was spent a lot with in terms of buying things for the children, you know, doing things that they really liked, when as previously historically in the relationship, that wasn't the father's interactions with the children. So the children, since the separation, were like, this is fantastic, this is great, and you know, we like this. And even though it was scary with dad, and we remember certain incidents and whatnot, things are better now. And so, you know, we want to see him. His access was supervised by his parents. And when I say supervised, I say that with air quotes, because we also quickly found out that the access was not supervised by his parents. And so there was a lot of concerns in regards to the custody of these children, the access that the children were having, and of course, very high needs in terms of criminal charges, CAS, and I would even say a high level of dangerosity in regards to mom's safety and the children's safety. And so one of the things that we also see in IPV cases is sometimes the perpetrator uses the court process to continue the abuse and control in the relationship. So parental alienation, we talked a little bit about that earlier this evening, and this is just my definition. It's not an official definition, but just basically it is the systemic manipulation of a child by one parent that results in rejection of the other parent. And the rejection could also be directed to extended family members. So a grandmother, you know, an uncle, etc. The child can exhibit fear, anger, disgust towards the alienated parent. The child may repeat what the dominant parent has to say about the parent. So, you know, my mom is lazy, or whatever the case may be. The child can have frivolous reasons or no reason at all for wanting to stop contact. And the dominant parent may be, as I mentioned in the previous case, the dominant parent may be buying the child's attention and love. So we see a lot in parental alienation cases, we see a lot of new gadgets and maybe a puppy and, you know, those types of things going on in order to kind of curry favor for the child. And I will say this though, with alienation, many do allege that alienation is going on. However, it is a very high bar, a very high clinical bar to pass. The threshold is quite high. So we would have to see all of these features plus some more in order to really say, this is a case of alienation, and even so, we're very careful in pronouncing that. Usually you would have to be considered an expert on the topic in order to actually say that. What we talk about is gatekeeping, undue influence. Those are some of the terms that we would use when we do see some of these behaviors. So another case example that we have in regards to alienation. So this is a case whereby the mother has successfully alienated the child, the oldest child, against the father. And so the eldest child is quite hostile, says that, he doesn't want to see the father, but can't really give concrete reasons. It's very fleeting. The eldest child is also now a co-alienator and trying to influence the younger child. So we do see that sometimes in severe cases of alienation. And so the eldest child, for example, when these kids were having access with their father, that eldest child would be monitoring, reporting back, texting back to mom in terms of what was happening between the youngest child and the father. Their interactions. Was it lovey-dovey? Was it cozy? Was the child, upset with father? Why was the child upset with father? So that eldest child was basically a co-alienator in the situation. And unfortunately, in this particular situation, as we were working through the case, we were losing contact with the mother. And it has become so severe that we no longer know where the children are going to school. When we speak to the school, they have no more information as to where the children have moved to. We don't know where the mother is located. The father does receive messages from the mother saying, children are fine, when he says, well, could you tell me where they are? Where are you guys? What's going on? He'll get text messages with laughing emojis and that kind of thing. We definitely saw a history of gatekeeping, lack of information sharing by the mother. And so we're literally in the situation just last week where the father is having to contact the authorities. We're not sure if we're able to proceed on the case because we don't have a mother and children. We don't know where they are right now. So that's a very severe case of alienation. And so our cases can range to something like this, to something that is a little bit softer and just kind of creeping in. So it kind of runs the gamut. So the COVID-19 pandemic. So as I mentioned earlier, almost immediately we started to see COVID-19, entering into the custody access dispute fray. And right now, parents need to make decisions with exposure to the virus in mind, right? So are they going to school? Are they going to do online school? Are they going to do extracurricular activities? Can they visit extended family members? Can they go on trips, especially, in the summer when the cases were lower, the COVID cases were lower. We got a lot of that in terms of whether people could travel outside of the province or to the cottage, that kind of thing. And so these issues now add another layer to the custody and access disputes, right? And children, of course, are greatly impacted by COVID. Many of them were, having to do online school in the spring, and to now have a custody dispute where COVID-19 or other factors are a feature. It's really a powder keg for kids. And so issues of abuse, alienation, high conflict, all of that has intensified over this pandemic. So on March 24th, Justice Pazaratz, who is a justice out in the Hamilton area, so with the Superior Court there, he released pretty much a landmark decision in the province and also just for North America. And so you notice the date, March 24th, it's literally, probably a week out after the lockdown here in the province. And so the mother in this file had filed a motion to stop access, basically saying, I'm social distancing, we're not going outside, and I don't want my child to leave the house in order to have access with the father. And so this case was heard probably a day or two prior to the release of the March 24th decision. And basically, what the justice is saying here is that, yes, COVID-19 is definitely impacting all of our lives, putting things on hold, but we can't indefinitely put on hold a child's relationship and access to another parent without causing serious harm and upset to that child. We can't have a blanket policy that says children should never leave their primary residence, not even to visit another parent. It's just not realistic. And as we can see with this pandemic, it's probably going to last for quite some time. So just imagine if we had court decisions talking about children not seeing another parent face to face for a long period of time. So it really was an important decision, and a lot of the decisions that have come after this really models this and quotes this in terms of jurisprudence moving forward with access and questions around COVID-19. So what are some of the issues that we're seeing with the pandemic? We do know that prior to the pandemic, some people were having supervised access. So perhaps there was an issue whereby there was instability, inconsistency in terms of access, or some kind of mental health or substance abuse problem. And so that necessitated supervised access. However, during the lockdown, many of the access centers closed. And even after the lockdown, some centers continued to remain closed, but some started to offer in-person access visits, so socially distant, supervised access. Some centers offered virtual visits. So those have been occurring. However, as a result, waiting lists for supervised access has dramatically increased. And what we're seeing now is that some parents have not had in-person access with their child for several months. And if they were having supervised access even before the pandemic, they're creeping up on a year almost in terms of no in-person access. So obviously, we're seeing people come to court and asking for our services in terms of, hey, what can be done to stop this, not being able to see my child in person. The other thing that we're also seeing is that when there is virtual access, sometimes we are hearing of complaints whereby the primary caregiver, so where the child is primarily living, is facilitating the virtual access, and maybe they're making comments while the child is having a virtual visit with their parent. Maybe the call drops all of a sudden. So again, we're seeing some access interference that is bleeding into the custody dispute because of the pandemic. We're seeing primary caregiver strain. So as Nicole had mentioned earlier, a lot of children in our community are being cared by a primary caregiver. And during the pandemic, if children are going to school online, someone is home with them. and that's usually the primary caregiver. And so sometimes the access parent just may not be available because, they have work obligations and whatnot. So the primary caregivers are saying, well, I need a break, right? I'm here with the child constantly, for school, and then it's the evening, and then it's bedtime, and then we do it all over again. Um, and so the access parent, however, may object to the child spending time with extended family members or a friend or whatnot because they are afraid of COVID-19 exposure. And so that is also adding stress to the co-parenting relationship. So the other thing that we're also seeing is separations and custody disputes due to the pandemic. So the pandemic itself has created separations. So say, for example, the relationship itself was not all that strong to begin with. The pandemic starts, and then the pandemic itself further exacerbates cracks in the relationship. And now all of a sudden you have parents who weren't planning on separating, weren't thinking of separating, but are now at a point where they can't be together anymore, but they still have to live together because of course they weren't planning to separate. And so imagine, as a child being in a home where you know that your parents don't want to be together, but they're physically in the house. It's probably one of the more difficult and extremely sad cases that we have to deal with. The other thing we're also seeing is that successful co-parenting relationships have deteriorated. So things were working great, COVID-19 starts, and then now there's lifestyle concerns, there's differences in COVID-19, and some people think, well, it's not that serious, some people do. And so now the parties are having disagreements as to what should happen with the kids. Should they go to school? Should they go to their friend's house? Should they engage in extracurricular activities? So we're seeing that. One, I guess, some of the silver linings, if you will, that we're seeing out of this pandemic is that all of a sudden, some of these custody disputes have resolved. So the complete opposite of what I was just talking about, and that basically this health crisis has really galvanized people together to work together and make decisions and communicate better around their children. So the custody and access issues are now irrelevant. Access has increased. The children are doing well, great communication. And so it's actually quite wonderful when we pick up a file, we contact the parties, and they're like, we don't need you guys because we've figured it all out. It's absolutely fantastic. And we did see an uptake and continue to see an uptake in that during this pandemic. So whether we're in or out of the pandemic, what is the impact of high conflict custody disputes on children? So some of the behaviors that we could see in kids is parent pleasing, right? So trying to say and do things that mom or dad would like. Some of the things we could see as well is behavioral changes in school, inattention, school truancy. We could see aggression in and outside of the home, opposition. We could also see sleep disturbances, regression in development. So say, for example, you have a toddler who is learning how to potty train. You could see, the child falling back on that. Appetite disturbances, so not eating or eating too much. And then with the older kids, we can see things such as drug use and abuse, delinquency, features of anxiety and depression, self-harming behaviors. So, we've heard a lot of some of these cases going to CAS. Sometimes we get the case. Nicole had talked about, having strangers trying to figure out some of these issues for you in terms of, if you're not able to effectively co-parent. These are some of the behaviors that you could see in the kids. And then, of course, you start to have all of these systems now intervening in your family situation, something that you necessarily did not want, weren't expecting, and not fully understanding how far the reach is. And I think that's really important for us in the community in terms of really understanding just how far things can go, and keeping that in mind in terms of the importance of effective co-parenting. So communication is key. We heard about the 5 C's. That was done really expertly by Stephanie. So communication really is the foundation of co-parenting, right? And if you are communicating and it's going difficult, it's not going well, then don't continue communicating in that manner. So if you're talking on the phone and it's resulting in arguments, move it to text. If the text messages are getting out of control, move it to email. And if the emails are not working, that's where you're probably in a high conflict situation. You may need to use a communication app such as Our Family Wizard or Two Homes. Your communication style really has to remain courteous and concise and about the kids. So it's about a goal, a specific appointment, exchange, access, whatever the case may be. And if you don't want to use one of those communication apps, then is there an uncle, an aunt, a friend who is, okay with your ex and is willing to communicate on behalf of you in order to facilitate vital information flowing between both of the parties. Unfortunately, and some of the cases that we have in severe disputes, the lawyers may have to handle the communication, or you might need a parenting coordinator. And so this is where things start to get expensive. Things start to get, a little bit difficult, but again, communication is key, and you need to find yourself out of poor communication. So in closing, remain child focused, try to find common ground, focus on the strengths of the other partner. A poor couple relationship doesn't mean that the parent is a poor parent, right? So sometimes we get hung up in terms of, I don't like this person, et cetera, but they could be a really good and strong parent. Seek support, go for mediation, just do not put the kids in the middle. Children do derive their identity from both parents, so do not denigrate, do not have those conversations in front of the kids or when the kids could listen. And that's pretty much it.